for the application is sufficient. It's merely a technical analysis, sort of akin to the clerk of court filing in a new complaint. It either is in proper form or it's not, and if it is, we file it. Where you find yourself under the applicable statute, and I don't think counsel and I disagree about this, is that you are engaged in a sufficiency review, which is akin to a probable cause standard, and actually probable cause is cited and referred to in the review statute 21-4-6.
I have it.
And so what you are to determine is you don't weigh whether or not the allegations should cause the person to be recalled or should not cause an elected officer to be recalled. What you ask yourself is if those allegations accepted would warrant a recall application as authorized under the statute. Now, there's two ways to sort of have that analysis. One is whether or not the allegations themselves are factually, there's a basis for them factually, or two, assuming those allegations to be true, do they rise to a level sufficient under Georgia law to allow a recall to proceed? And it's the second of those scenarios where you find yourself today. And I, again, don't anticipate disagreement between me and counsel in that regard. There is not a dispute in this case, and as a matter of fact, I've acknowledged he has brought the video, we had brought the video, we spoke before you came out, and I don't believe there's any objection to, for today's purposes, Your Honor, watching the video of the meeting issued as part of your analysis in determining whether or not what occurred at that meeting would rise under the statute to sufficiency for a recall petition. So in other words, the facts are not in dispute. It's whether or not what on these facts would constitute sufficient basis for a recall, if that makes sense. And so to give you what we would submit is the applicable law on the subject, the recall statute, and the parties have cited this to you in brief, that you are called under the public elected official code section, is sort of a waterfall provision of Georgia law. That is, it kind of tumbles down from the state level to the local level. And we start our analysis under OCGA 21-4-3, subsection 7, grounds for recall. And again, both parties have directed you to this operative code section. And what it says is a two-part statute, that the official, while holding office, conducts himself or herself in a manner related to or adversely affecting the administration of office and adversely affecting the rights and interests of the public, and, so it's a conjunctive statute, the official has to have been alleged to have violated one of the following. A, or little I actually, subpart B-I, committed an act or acts of malfeasance while in office. Little 2, has violated his or her oath of office. 3, has committed an act of misconduct in office. 4, guilty of failure to perform duties prescribed by law. And then 5 is not really operative here, that's misappropriation of public funds. What we would submit to you is under the middle 3, violation of the oath of office, commission of an act of misconduct in office, guilty of failure to perform duties prescribed by law, are what we are traveling under here. In this case, the petition states that the Board of Commissioners, under the direction of the petitioner for review, Mr. Agnew, had failed to conduct discussion prior to a policy action item, in this instance specific to the modification of the school calendar. In this instance, the calendar has been here a 4-day school week for a significant number of years, like 8 or 9 years, and the vote was taken to move to a 5-day calendar, and as you'll see in the meeting, there was no opportunity for public discussion at that meeting on that decision. And to get to whether or not that act, the failure to seek public input prior to a policy decision, we have to work our way downward to the Code of Ethics as mandated by state law. So we commence our analysis at OCGA 20-2-72, and I brought for counsel, that's one for.
I have noticed gentlemen, there's some pleadings attached that I don't have copies of. I don't have any of you, I don't have any information
I've got copies for you of all the pleadings that have been filed, as well as the statutes that we're traveling under. I brought that just in case something didn't make it. Okay, if I can approach. Those are the statutes, and I brought copies here of. So the petition for review, the motion to dismiss, it's really the brief in opposition that I think you may not have. Got it. There you go. All right. So again, back to the question of what violation of public law or oath of office are we addressing here? We start at OCGA 20-2-72. And OCGA 2-72 was created by Senate Bill 84. And Senate Bill 84, which created that, established a model rule of ethics for local boards of education. The reason it's important that we take ourselves back to this code section and we take ourselves back to Senate Bill 82 is that in this case, code of ethics for state boards of education are not just suggestive and they're not just model practices, but they are actually a mandate of state law, which is important when we talk about whether or not an elected official has committed a violation of state law. So that code section, 22-72, created the mandate that all local, specifically subpart B, within 3 months of passage, all local boards of education were required to adopt a code of ethics which modeled in part a model code of ethics which had been promulgated by the state of Georgia. And so our next step down the waterfall then becomes the state of Georgia's model code of ethics. And in this case, you find that at Georgia State Board of Education Rule 160-5-1-.36, which is a mouthful. That is the local school board governance section, which includes the model code of ethics for local governments. And in this case, the Chattooga School Board, County Board of Education, has in fact adopted in almost identical part that model code of ethics. And their code of ethics is also given, I've given that to you as well. And the operative provisions of their code of ethics, which mirror the model code of ethics, which are part of state law, state as follows. So this really gets to the meat of the issue. 1, under domain IV, domain 4 of their policy statements, it mandates that the board may make decisions on policy matters only after a full discussion at a publicly held board meeting. So that's model domain 4. Model domains 2, 3, and 4 also contain some related provisions. Model Domain 3, which they've adopted, Part 1 states that the board must seek regular and systematic. I'm sorry.
I'm trying to follow you.
That's all right.
Domain, what number?
3. I. Domain 3 states that, Part 1, the board seek regular and systemic communication among the board, students, staff, and community. And then if we travel down, again, continuing our waterfall to domain 5, they are mandated to make decisions in accordance with the interests of the school system as a whole and not any particular segment thereof. And we would submit, and I'll give you some additional authority here in just a second, that taken as a whole, this model code requires that the public be presented with the opportunity to address the board in a public forum prior to a policy decision being made. And there's no dispute that in this instance that did not occur. The last thing I'm going to... Go ahead.
You said that, what you just said before, but you were reading it from something, and I didn't keep up. Well, the money, you were saying to me, sorry, I'm trying to understand. You were saying to me that if there is a matter of public policy, there must be an opportunity for public input.
Under their code of ethics.
Well,
All right, so domain 4, which I'm going to give you a little more authority on.
okay.
Domain 4, part 2. Make decisions on policy matters only after full discussion at publicly held board meetings. Now the question is, really what the heart of today is, what is full discussion? Does that mean public discussion, board discussion? What does that mean? And I've got one additional secondary authority for you that is going to suggest that in our mind, full discussion includes public input, because in Georgia, the state school superintendent at the time had published materials called the Standards for Effective Governance of Georgia School Systems. Okay? So this is like, if you think about our rules of professional responsibility, we have the canons, we have the rules, and then there's the notes that guide us as to what the rules mean. The state school superintendent has done something very similar in this instance and published a more expansive document, which we've provided to you. It's the Standards for Effective Governance of Georgia School Systems, which gets updated. This is the 2010 update of that. And in that update, he goes through, that is the school superintendent of the state of Georgia, the various domains. Okay? And he sort of gives additional elements of what those domains mean. And if you look, this one's kind of hard to find, but on page 10 of his materials, the pages that are numbered, he has a chart of domain 4, policy development. So what does this mean when it says policy should include full discussion? And it says under elements, element 4, the board provides opportunities for public review on proposed policies before final board action is taken. So that's a further expounding upon what this means, and our timeline is going to become critical in this regard. Okay, and then when you move now to what happened in this case, which is not largely disputed, and you'll watch the meeting. What happened in this case is this decision was the decision of the board of the county schools as constituted on January 17, 2019. It was their regularly scheduled meeting on that day. And what you will see in the meeting, and from the minutes of that meeting, is this board action item was the first action item on that the board undertook after they did several very critical things. One, they were sworn in, because this is the first meeting of the year. And two, the petitioner here was nominated and elected as the chairperson. And then the meeting commenced, and you'll see that play out on the video. They made an agenda, a vote to move something on the agenda. They dealt with that, and then they took up this. There's a motion for discussion. There's discussion from the board. But when they hit public discussion, you'll hear the gentleman, who's the superintendent who's running the meeting, say, none. And at one point during this meeting, you'll hear the crowd kind of, and they actually cut off, and he says, no, in other words, there will be no public comment. At this time, they continue to discuss, and they have a vote. So our position is that this board never had public comment on this issue. You may hear, I'm not sure, but if there's an attempt to say, well, this issue had been debated during the election and this issue had been debated before January, That might be fine and good and true, but that's not an act of this board. Because this board, as constituted, was not sworn in. This board didn't exist for practical purposes, legal purposes, until this meeting started. So this board, it's not possible for this board as constituted to solicit public opinion and public comment because they were sworn in and he was nominated and elected as chairman right before this vote occurred. So this board never held any public forum or any public meeting on this issue. And I would submit to you, when you look at those domains, they're required to solicit public comment and public opinion and engage the public prior to making a policy decision. And in this instance, that was violated. And the import here is that that mandate, as we work back up the waterfall, is a mandate of state law. This isn't a model ethics code that was passed locally and we all should agree that these are best practices. The model code here is a function and requirement of state law, which this board has submitted itself to. So whether or not generally you're supposed to engage the public, this board has imposed upon itself by virtue of state law that requirement. And they're then bound to follow it. The last thing you may hear, and I'll address, is that, well, the public, and they have a mechanism in the county to sign up for an agenda item for public discussion. Well, that sign up has to be submitted prior to the meeting. And if you read the requirements that they have on that sign up, that is to add an item to the agenda, not to discuss an existing item. The public discussion requirement is not public comment on the existing agenda. That's, I want to put on the agenda that the playground over here is in disrepair, and I'd like to talk about that at this meeting. You can have that added to the agenda by filling out the form. The form makes it clear that this is not submission. If you go to a meeting, for example, of the Cobb Board of Commissioners or other boards of commissioners where I've appeared on a zoning matter, at the back of the room, there's a sign-in sheet, and you sign in by agenda item, and there's a public comment period. One is public comment general, where you sign up in advance. I want to talk about the playground that's in disrepair. The other sign up that virtually every public meeting has is to sign up specific to an agenda item. Now, they have the right to regulate that comment. Everybody gets 2 minutes. You can't be disrespectful, and there's no doubt about that. But you have to afford, on a policy item, the public the opportunity to be heard. It's a fundamental aspect of our system in this country, which is the right of the public to address in a meeting its government prior to a policy decision being made. And in this case, that simply did not occur. It didn't occur at any meeting before this because it couldn't have. There were no town halls. There was nothing taken to engage the public on this item. We submit contrary to the model ethics code, which has the weight of state law. Therefore, that would be sufficient, if found valid, to be a violation of the oath of office and to be misconduct in office, which would then warrant would be sufficient to sustain a recall petition. Now, it's up to the public what they do with that. They still have to go forward from here, gather the remaining signatures, get on with that. That doesn't mean he's out. It doesn't mean he's in. You're not deciding any of that. You're just placing it in the hands of the folks who carry it forward from here and determine whether or not it's sufficient based on their role as elected. And we believe on that basis the matter should proceed. Thank you.
For the petition, Chattooga County, Everett County, now the Constitution satisfy the Constitution. The Constitution, paragraph 2, Article 8, Section 5, paragraph 2, says that each citizen shall be, I'm sorry,
Give me the numbers.
Article 8, Section 5, paragraph 2. Says the school system shall be under the management and control of the Board of Education. So I also want to Education don't run the school system. Superintendent runs the school system. The Board of Education establishes policy. Superintendent carries out. This petition is inadequate both in form and in substance. The purpose of a recall petition, the purpose of a recall petition itself is to notify the official that's being recalled what was done. And it's also to notify the public who's voting on the recall what they're voting to recall the petition to the person for. And this recall petition is inadequate in that it's full of conclusions. There are no facts. It doesn't say that the public wasn't allowed to participate. It says that there was no discussion. So the public now voting on this recall petition is unaware whether we're talking about the school board didn't participate, no discussion, or not. So the form of the recall application is insufficient as well. On the substance, you'll see on at this tape we have a meeting. Well, first of all, let me say this. The system set up in Chattooga County is that people are allowed, anyone is allowed to address the board on any subject. All they have to do is sign up, and they're allowed 5 minutes each to talk to the board on any matter before the board if they want to talk about it. And history will show that prior to this meeting, a group of people have been coming talking about the president to the board on the 5-day holiday, which is the basic problem in this case. The school board voted to return the system to a 5-day school as opposed to 4. Back in 2000, I think that was going to show that 2006, 2008, in that period, during the time that the state was having problems financially, the school system here went from a 5-day system to a 4-day system for economic purpose. Really what the bottom line of this whole petition is, folks don't want to go back to a 5-day system. Evidence is going to show that the board members who voted to go back to a 4-day, 5-day system ran on and were elected on the proposition that they would vote for a 5-day school system, which is going to take away from this hearing or this meeting of this year. The agenda, we have the agenda very far. We also have the tape of the meeting. The agenda there's a provision that if you want to sign up, you can. No one signs up to talk. And in the course of the meeting, the motion was made. Although I don't know, I've listened to the tape. I haven't heard the roar of the crowd. The council refers to. But no one in the audience asked to participate in the meeting. There was a full and vigorous, I think, discussion among the board members as to whether or not the new system ought to go after the 5-day system. That was a vote of 4-1. One of the members of the board voted no. After discussion, no one on the board complained that he or she was permitted from discussion, full discussion. And the code of ethics referred to, it doesn't require a board at every meeting to allow full allows people from the public to come and not sign up, regardless of the procedures of the board. There's no requirement under the code of ethics that the board cannot proceed with its business unless some member of the public is there to participate. And that's not my reading of the code of ethics. There was full discussion of the board. The board has authority to do what it did. And our position is, you'll see Mr. Agnew was not running the meeting. It says that in here that Mr. Agnew allowed no discussion. Mr. Agnew, the board, one board member doesn't have the authority to act for the board in the first place. If there was any discussion tonight, it wasn't done by Mr. Agnew. Mr. Agnew, though chairman, you'll see the board was run by, the meeting was run by the superintendent. So Mr. Agnew hasn't prevented anyone from discussing, and no one asked to participate. This matter, these folks who are on the board ran for the position on the proposition that they were going to vote for a 5-day school day when they got elected. They won the election based on that proposition. And they exercised their constitutional right and authority in a board meeting with the authority to go to a 5-day system. That's their authority, that's their position. And we think that I can understand the stretching of reading the code of ethics. I don't follow his logic. But the board has the authority, constitutionally bound. This is not a statutory issue, this is a constitutional issue. The board has the authority over the school system. And it exercises properly after full discussion of the board. I don't believe there's any violation of any code of ethics in the time of Mr. Agnew or any other members of the board. That is clear that that's the case, and we can present such evidence that they want to go forward with. But we don't believe that there's any position. And Mr. Agnew is entitled to vote for a 5-day system. The board is entitled to vote for a 5-day system, and it's done properly after discussion with the board in public, and the board position is to be enforced.
Whatever I do on this, the board's vote stands.
That would be correct.
Whatever I do on this, the board's vote stands.
That would be correct.
This does not change the vote of the board.
That's correct. There's no allegation, there's not an allegation that the vote itself is somehow misrecorded. Judge,
Go ahead.
we've stipulated as to, Your Honor, reviewing the meeting, and then we've got the, I think you referenced the agenda in the minutes. The only thing we don't have is that form, I thought I had it, which is the public request to speak form. It's required to be, perhaps we stipulate to it, it's required to be submitted 5 days in advance. That the public participation form that you'll see must be submitted by policy 5 days in advance. So I guess procedurally, if you want to hear more from me, I can respond, or if you'd rather watch the video and then hear any additional argument.
Put up whatever you think. Make me understand what you're talking
All right, I think going ahead, we both intended to show you the meeting, so whether we can just put it in.
And I'm all trying to with Doug Fallon, Jimmy Houston, and Brad Hayes. Typically, Petition and then employees, city board of education. And the recipient of public funds delivered as such employees. We hereby solemnly swear or take firm will support the Constitution of the United States and the Constitution of Georgia. We further solemnly swear or affirm that we will seek true and faithfully discharge all the duties required of you by law as a member of the Board of Education of the county. To the best of your ability. We further swear or affirm that you will not hold any subject for public money in the state or any political subdivision or authority thereof, that you are not the holder of any office or serve the government of the United States, nor leader of the federal state, nor of any foreign state. And if you are otherwise qualified to hold that office according to the Constitution and laws of Georgia, and that you will support the Constitution of the United States and of this state, and that you have met the residents of the requirements of this office on which you are. That's not good reputation. And one more time, please. We refer to you and the employees of the Board of Education, and the recipient of public funds for services rendered as such employees, hereby solemnly swear and affirm that you will support the Constitution of the United States and the Constitution of Georgia, so help you God. Thank you very much. I don't. Of the board members present, along with the superintendent and assistant superintendent. Now, what I need to do now, if you'll see, there's a lot of you have to do to get stuff on the agenda. First thing is, need the motion. I do not have the authority to make a motion. It has to come from. Need the motion. Go into the agenda. And what I'm going to be asking, you go down to item C, and then move it up so we can vote for chairman and vice chairman. What I need from somebody is a agenda. Now we need to vote. All in favor of allowing me to amend the agenda, please raise that hand. It's unanimous. Now I'm going to need another motion to move this, I need a motion to move agenda item C, which is two more policies, talking about chairman, vice chairman, election of the board chairman and the vice chairman, between the adoption of the superintendent's amended agenda and approval of the previous amendment. So I'll need a motion to move that. Everyone in favor of moving that forward, please raise your right hand. Unanimous. Now, we need the new agenda that you were given. So the one that you were given last week, please put that aside so there has been changed. After the adoption of the superintendent's amended agenda for January 17, 2019 school board meeting, I need a motion to approve that. Mr. Turner, and I need a second. And now we need to vote. Everybody in favor of, raise your hand, please. It's unanimous. Now we're down to school board policy. Yeah, this paper, let me make it get a little more complicated than what I read. here. Do I have a second on that? Do we have anybody else that wants to make a recommendation? Do we have a second on that? No second. Now, even though we only got one candidate, we have to vote. So again, have to have a recommendation to vote now for the hearing. Now we'll vote. All in favor, say aye. You do the chairman, we'll raise our hand. Congratulations. That is it. Congratulations on the award. You got a job that you don't like for a lot, you probably know that. It's very difficult. We appreciate it. People like you know how to run part-time, so it's very difficult to do something. Now we've got to, so John, I do one or two things. I can continue on, or you can take over if you want. So we got to we just go ahead and now what we need is someone to recommend someone to be the vice chair. We want to make a recommendation. What we need to do now is we'd like to have a vote for the vice chairman. I need someone to make a motion that we vote. Now what we're voting on is Mr. Sam to be vice chairman, everybody for that three-way raise their hand. Congratulations. What we'll do, if you don't mind, if you'll notice, we do not have the time for chairman and vice chairman. When I moved over here, these are his. When you're standing not on the end, that's why I recommended that the chairman take that or move over. Because you can't see everybody when you're looking back and forth before the curtain. So, if y'all want to turn the next forward, you can say the same thing, or we're going to put a chairman and vice chairman. I think y'all what to do. You'll have to do more left and right. Look at that. Just think about that. So we'll, now we're going to move to we need to have a recommendation to approve the minutes of previous meetings. Need everybody to make the motion to approve that. I'm sorry. I didn't want to do that. And now, we need to vote. We're voting to approve the minutes of the previous meeting. If I approve, please raise that hand. Don't. That is unanimous. Now we have public participation, which is none. We have resolution recognition, which is none. Now we have the board school members. We had some school board members which have made some, they like to have some things on the schedule. We have put that on there, but we need to make sure that the board approves it if they want to be on. School board members, board consideration of superintendent's recommendation for discussion on the following questions and issues for board member Julia Houston. I want to make a recommendation to accept those and move on. And you have a second. Now we need to vote. Everybody in favor of this? I know it's a lot of big things right now. Now let's use the there what would you like for us to do on this item? Discuss it, or you can make a recommendation when you vote on it, or whatever you would like to do. It would be consistent with how what you like to word on. Okay, so you would like to make a recommendation that we vote on whether we have 5 days or 4 days next year with no discussion. Just one straight vote. Do you want to discuss it among yourself, or you just want to vote? Let's discuss it about that. Yes, it is. You know, there's one discuss it. I'll second it. So now we're voting. We don't do stuff here. Your recommendation is some things most women out there, but look, that's a little bit vote on there. Go back to the back there, or not, those are votes yeah, that's what you have to make. Well, that's it. You're not wanting to vote first, you want to discuss. Yes, I think that's what you're trying to do. You're asking to be able to discuss. So what we're doing is we want to discuss. We're bringing on this, and this was made a motion to discuss the fact that we're going back to that. We're ready to assess that. We vote to have that discussion. And have that discussion. So everybody is more discussing, please bring it up.
Therefore, funding continues, so now
I've been in for years. Get back on something. When we started 8 or 9 years ago, they said 2 years max is all that will be on the board there with the funds that we didn't have with the vote. And that didn't pan out. It's still going on and on, and I think it's a vote. Well, especially for the young kids, they need some consistency, they need some regularity in the learning experience. And I don't think we're getting that. We're learning that is.
I would not really be opposed to, necessarily a 4-day or a 5-day. What I have found in my research is it appears, now we can't predict the future, but it does appear that in some research, the state, and when I say state, I'm not saying the governor or the education department, but I'm saying the state legislature. They are looking at setting a school calendar for the entire state of Georgia. And when you hear that, you may say, hey, yeah, that's probably the best thing to do. Because when the students in one school system and they may move, he's going to go right into another school system in another county or city and be back on track. And I'm afraid that's coming because there is a state senator from a South Georgia county that has got into an agreement with the state legislatures that they have a study committee formed. Now, when I researched who's on that study committee for this calendar that might be for the entire state of Georgia, it hurts me to see there's not even an educator on that study. It's tourism. It's business. But if that's coming, and they create a calendar for us to have to start on and end on, as a 4-day-a-week school system, we're going to be hurting to get in the 180 days and have 4 days that we're going. And I mean, Murray County, I love their calendar. They start after Labor Day. They go 5 days, but see, they're going to be a school system that's going to be hurting too when they have to start and end, and their day will get longer. And I really do think, because of that burden coming down the pipe, we need to be on a 5-day if that's happening. Because when committees sit around in the state of Georgia, they're not thinking about, that little county up in northwest Georgia. They're on a 4-day. They're setting an agenda, a calendar that's based on 5 days. And if that's going to happen, that's where I feel like it's best for the students and everyone that we're on something that the state was going to set.
I think that we are vastly approaching a new world. I feel like that artificial intelligence is becoming so introduced to our culture, and that it speeds learning up so much that sooner or later we all will be on a 4-day week. That includes mill workers, everyone, because with artificial intelligence, you've got to figure this in. I know it sounds a little bit off the wall, but artificial intelligence is to the point now where it is, I think it's really controlling us. And if I say this because I kind of follow this sort of trend, and we have robotics, which is coming in. We were first set up on the agrarian calendar. The 5-day week was the agrarian calendar. Technology has become so advanced now. Robotics and artificial intelligence has already hit the singularity, and we're at the point now where you will see, and I'll make this prediction right now, you will see within the next 2 years such an advancement in bringing artificial intelligence into our culture that will probably make the head swim. With this in mind, it is my feeling that we are probably ahead of the curve on the 4-day week. And I worry, even if we were to go back to the 5-day week, how much disruption that would cause the whole system.
Yeah, everybody now seems to be is pretty well content in the groove of following the 4-day week. I fear that if we come in and just do something dramatic and change it to a 5-day week, that we're going to have a lot of problems that are created through morale. And I think that's the most important thing we have to deal with any kind of system that deals with humans is the morale factor. Lord knows that I've worked in the system for 30 years, and I've seen how bad it can be, and I've seen how good it can be. And my biggest fear is it goes back to how bad it can be. So that's my thoughts on it. But you might want to look up a little bit on artificial intelligence and robotics. Just go to your Facebook site or your website. Find it on the website, look it up, because it's here, and it's exponential.
I would like to address I think there are a lot of concerns about returning to the 5-day WB programs, and I think just in general that we would these programs that are 5-day would not cause us to have to cut any programs. Our programs would remain in place. All of our arts programs, our school enrollment programs, our teaching therapy programs would all remain in place. And I think our bottom line has to be doing what's in the best interest of our students and making these decisions.
Well, I see your hands raised. I'm sorry that these. Oh, I'm just saying, okay, I'm sorry. Yeah. I'm sorry on that too. We have a meeting. They would have to approve that you would do that already asked you. So we see, but please, the simple thing. Thank you. They say this, we have anger. And there's a lot of rules and stuff, and if anyone ever wants to speak, they do have to come down to the office a week in advance. But yeah, thank you very much. Any other comments on that?
They were mentioning about being a hardship. I know all y'all here think they're teachers and don't want to do anything yet. 8 or 9 years ago, the school board voted to switch to 4 days, and nobody was concerned about hardships. They just changed. They didn't make a judgment call and did. And that's what we're doing today. And that's what we're making a judgment call. They did it 8 or 9 years ago, and we'll see what we'll see.
I would have to speak up and say another way that I would not support a 5-day. Going back to is what Ms. Houston alluded to is if there are parapros that are cut, or if there are programs that are cut, or if there's taxes that go up, because I'm a taxpayer just like all of you are, we can't do that. But a 5-day is not really out of the ordinary because we've been there before. And I've heard a lot of people, I've heard parents and students and teachers say, well, I'm just going to leave the system if y'all go back to 5 days. But the truth of that is you really can't go anywhere else in Georgia and be a 4-day. I mean, you're going to go to a 5-day. It's just that we're very rare here in Northwest Georgia, but that's going to be part of what these committees and these state officials that are going to be setting policies for us are looking at. They're not really going to think about the school system in Chattooga County is a little different. I don't mind being different, but I'm doing, what I feel like is best for students, but then I also want to be an advocate for parapros and teachers and administrators, but then also be, I know I'm an elected official for the community, which are taxpayers. So number one are the students, and sometimes settling for less is not always the best way to go. So whatever we can do to give students more opportunity, that's gonna be the best.
Well, I beg to differ. I think the best thing you can do for a child in the school system is to make sure that it's a happy environment and there's no confusion as to what they're going to be doing. And it seems to me that things are going pretty well on the board day, and it just seems off. I guess what I'm trying to say, why don't we run a survey with all the teachers and students and all and see exactly how they and there, excuse me, the vote. Yeah, and that's my opinion on it. Before we do anything, let's check all the different levels of education, your parents, students, teachers, and just see exactly what they feel like, how we do. That's all I have to say.
Any more comments? Recommendation to vote on 5-day employment. We'll go to both of them. Some may go to 5, some may go to 4. We need to, some way y'all, let's say we need vote or either 5-day or 4-day schedule this fall. What we will do first is go to 5 days, vote. I'm sorry, we'll do 5 days. We're going to do 5 days, so that's all it's on there. So we'll go, if you have 3 out of 5, I'll make a motion to vote on the 5-day schedule for the fall. All in favor of going to a 5-day schedule in the fall, based upon the legislators' days of starting. You're for 5 days, raise your hand. 4. You said 4 to 5 days, I'm sorry, 5 days, 4 years. Oh, okay, you're going to, yeah. Please, I'm sorry, again, the granted we have, you cannot, if it's not before, without being on the agenda, yes, we have to perform all the different things. But based on the vote, we will be on 5 days, we will prepare a 5-day schedule as soon as we get guidance from legislators to start and drop the day. But we don't know, we normally start, I think we want to first all this, we don't know when they allow us to start. We don't need to move the schedule 4 or 5 times, but it's a while before we have to submit that. So, based on that, we'll go 5 days. Next one here is the discussion concerning adopting a reading program for the 2019-20 school year.
Yes, it goes on about 4-H and some other things. Judge, just before we that was played by stipulation, but just to make sure we have a record, make that R1 drive you have needs to be actually received. That's fine. I have 2 other items. No objection, both intended to present them to you. And I'm thanking Mr. Agnew to authenticate them. I call him or do it by stipulation. It's the agenda, the minutes, the agenda from January 17th, 2019, I have as R2. This is published on the district website.
Yeah, that's fine.
I think you have it as well. And if we can stipulate, this is published, the agenda, or I call it, is published the day before the meeting. This was published on January 16th to the public.
I don't know that.
I'll call Mr. Agnew for that purpose.
Mr. John.
Raise your right hand. You solemnly swear testimony you shall hear and give shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes. And proceed on the cross. Even though I'm calling you for a vote. Just for officials to say.
It's calling it for
You are the chairman of the Chattooga County Board of Education. That's correct. Responsible for the administration of the meeting. Correct. All right. The board sets an agenda for the meeting, and there is a public participation form for that meeting. Correct. And the form, the policy of the board, as we heard referenced, is that in order to be present and speak at the meeting on the agenda, you have to submit that form in writing to the clerk at least 5 days prior to the meeting. That's correct. This is the agenda. I've marked it as Exhibit R2 for the court, and that's a copy. You recognize that as a true and accurate copy of the agenda of the meeting of January 17th, 2019. Yes. And in this instance, county records reflect that that agenda was published to the public on January 16th, 2019. That's correct. So it's typical the agenda is released to the public a day, maybe two, in advance of the meeting. Correct. All right, and then R3 shows council. This is the minutes. R3 I've identified as the minutes of that meeting. I asked you to look at those. The published copy wasn't signed by the clerk, so you can identify that those are true and accurate copy of the minutes of that meeting as R3. Yes. I'd ask R2 and R3 be received. That's everything for That's everything for
Mr. Agnew, you served before, is that correct? And during that period of time, has there been discussion about the 4-day, 5-day system?
Yes, there's quite a bit of discussion at various times at different meetings.
This was prior to January?
Yes.
Okay. When the additional members of the board were elected, did they run on proposition that they were going to vote for a 5-day school system?
Yes, their basic campaign was that they wanted to move the school schedule to a 5-day system.
During the time you've been on the board, have people appeared before the board exercising their right under the 5-minute rule?
Oh, yes, my previous 2 years, people would, come 5 days ahead and ask to speak, and they would come to speak at different times.
Did the board limit them in any way about how or what they can talk about during that 5 minutes?
No, there were no limitations. They could talk about anything concerning the school system.
Did during that course of time, people come and talk about the 5-day, 4-day system?
Yes, that's true.
Since January of this year, at the meetings you've had subsequent to January the 1st, other than the meeting on the 17th, no one signed up on the 17th, is that correct?
That's correct. Nobody signed up for that
But
particular.
since then, have people come and talked about and exercised their rights under the 5-minute rule?
I'm sorry?
Have people exercised their rights in the February, March, April meetings?
Oh, yes, very much.
Do they talk about whatever subject they want to talk about?
That's correct.
You all try to limit them in any way?
No, the only limitation they had was 5 minutes. They could speak for 5 minutes.
In the meeting on January the 17th that we just observed, did you in any way impede the right of any of the members of the board to fully discuss the motion on whether the system should go to a 5-day system?
No, as you can see, we all talked, and like I said earlier, I was not in charge. The Superintendent Luna was in charge as chairman. So I was not acting as chairman of that meeting, harmful.
Even though it may not be on this video, did you in any way try to influence Mr. Letterman to prevent any kind of debate at the meeting?
No, sir.
Did you discourage any of the members of the board to not exercise their rights to discuss the issues before the board, particularly on the 4 or 5 day rule?
No, we're totally open and be able to discuss freely with all.
Did you have the opportunity, as far as you know, to exercise your right to discuss the merits or demerits of the 4-day versus 5-day school period?
Yes, I did.
Why did you vote for the 5-day?
I just felt like a 5-day, I still felt that way. I think the 5-day schedule is set up throughout the United States schools, and I think it's the best schedule, and I think concentrating all that information material in 4 days is hard for the students, especially the younger students. I think it's hard for them to comprehend that much. And the long day is also part of the students as they try to process that material from early in the morning to late in the afternoon. It's very hard for them.
Do you feel like you made the decision to go from 4-day to a 5-day after the opportunity of the board to have a full discussion of the merits and demerits of that question at a publicly held meeting of the board on January the 17th of this year? Please.
I'm sorry.
Do you believe that the decision of this board to go to a 5-day school period or student period was done after full discussion of the board members at a publicly held meeting?
Yes, I think they had all the opportunity to speak what they thought and had the opportunity to vote, and that's what happened. Very justified time.
In regard to this policy and other policies that the board has passed while you've been around, did you do so working with the other board members to establish effective policies, in your opinion, for the school system?
I think so. I think we're very careful to try to follow all policies we have, and we have done that in the past.
Do you think that you were acting in the best interest of the school children?
That is our main objective, the children, the whole system.
Have you been informed and prepared to discuss issues to be considered by the board at its meetings, including the meeting on January the 17th?
Yes, we always would get material a week ahead of time, look over it, and get sort of formulate in our mind what we wanted to do if we came to the meeting. Yes.
Under the confines of the open meetings laws, have you discussed those issues and policies with other board members freely and fully to the best of your knowledge and belief?
Yes.
Have you worked with other board members in a spirit of harmony and cooperation during that period of time as best you could?
Yes, yes.
Obviously, you may have some difference of opinions on the board, but if you try to work with them in the spirit of harmony and cooperation and proper decorum.
Yes, I think we try to do everything as a body, make a decision as a body, but sometimes we do have differences of opinion, and when it comes to a vote, sometimes we have differences, but basically we operate as a body and try to be unified.
In fact, a board has to operate as a body.
Yes, that's the only way board education works. I don't have any power. The board members, it's the board itself that has the power together.
In fact, the sole member of the board has no authority whatsoever, do
That's
you?
correct.
You only have authority when you're working and voting on policies of the board properly brought in public meetings
Correct.
and fully discussed by the board at public meetings.
That's right.
And you've done that.
That's correct.
Apart from the policy question, have you talked with citizens of the county about the 5-day, 4-day system?
Ever since my campaign back in 2016, I talked to them on the county. You know, that was my thoughts early on, that I thought the 5-day system was best, and that's what I was running them. And as I talked to people, many people agreed with that.
Have you talked to the teachers? Have you talked to the students about it?
And some teachers liked it, some didn't. Most students really liked it, but I have to look at the situation, what's best for the students, not what they particularly like. And, so I felt like the 5-day was better for the students, even though most students really like to stay with it. I like that 3-day weekend.
So what day of the week, normal day of the week, does the school system right now open for business? What day is it? I know it's Saturday and Sunday. Is it Friday or Monday?
Monday.
So you don't start school until Tuesday?
Tuesday.
And how long does the school day last? When does it start? If you know.
A few minutes before 8, I think maybe it goes like 15 to 8, something like that. It goes to around 4 o'clock.
So it starts before 8 o'clock in the morning, and it goes until after 4 o'clock in the afternoon.
Good after 4, I think.
4 days a week. Now, that's longer than the normal school day.
Yeah.
Does it concern you, particularly the young students who are unable to pay attention for that long of a school day?
Yeah, I feel like especially the kids in the outlying areas have to get up early in the morning, sometimes get on the bus at 6:30 or 7, and then sometimes don't get home till 5 to 5:30. And for young children, you know, that's just hard on them. Plus having to, when they're studying in school and trying to learn, and when they get around to 12 or 1 o'clock, they've been there 4.5 to 5 hours, and they're tired. And I think mentally it's hard for them to concentrate and to remember material and to work, you know, well that afternoon. And they just don't do that well because of that.
Have you been concerned, or are you concerned about the academic performance of the students in the system?
Yes, I think our scores were low. I think we're in the bottom 20% of the scores in the state of Georgia, and yet the school system itself spends about, I know we're in the top 20% as far as how much we spend per student, and the two things just don't add up. And I think part of that is the 4-day system.
What about the reading ability of the students?
I think we've gone beyond the proceeding a little bit. I'd let go just to give some context for why this was an important issue, but the merits of it and state rankings and everything are getting a little far afield.
Well, I think I'm just trying to get from Mr. Agnew the basis of his vote.
The basis of his vote is irrelevant. I was sitting here enjoying listening to his arguments and the law. I'm not here to rule on whether it should be a 4 or 5 day.
I understand.
So what the arguments are, either way, is not material to my ruling. It's interesting, but it's not. I will not rule one way or the other. So as for this proceeding, it's irrelevant. So I just have an objection.
That's all I have.
Just one quick for clarity's sake. This meeting, the January 17th meeting, the board members were sworn in at the commencement of this meeting. Correct?
Correct.
Even though you had been previously served as a board member, this board is constituted. This meeting was the first official forum in which this board had met.
That's correct.
And the board members were sworn in at the commencement, so they were not acting as board members until the commencement of this meeting.
That's correct.
That's it.
That's it.
That's everything. Nothing else.
Why don't we take a morning break?
Thank you.
I'll take about this. I make it.
Thank you.
Oh, of course. Let's say 20 to 11.
Perfect. Thank you.
You solemnly swear that the testimony that you give here before the court shall be the truth, the whole truth, and nothing but the truth.
I do.
Please be seated. Could you state your name, please, ma'am?
Julia Houston,
And Miss Houston, where do you live? Where do you live?
Somerville.
And what do you do for a living?
I'm a professor of early childhood education
What,
at Shorter University in Rome.
when were you elected to serve on the board of Chattooga County Board of Education?
I was elected in November. Is that, I'm
Yes.
sorry, is that your question? When?
Yes.
I'm sorry, I'm not hearing real well.
I'm sorry, I'll try to speak up. When did you first take your position? At the January 17th meeting?
Yes, sir, January 17th.
Now, there's been introduced this morning a copy of the agenda for the January 17th meeting. Your Honor, if I could have that. Just sure, make sure I'm showing the light. Yes, ma'am, thank you. Let me show you what's been marked, what committee is R2, which is the meeting agenda of the Chattooga County Board of District. See if you recognize that document.
Yes, sir.
And earlier there was testimony that these agendas are published the day before the meeting. Did you hear that testimony? You've been here in the courtroom.
Yes, sir.
Do you have knowledge of when this particular agenda was published?
This particular agenda was released to all in Georgia at least a week prior to the meeting.
How do you know that?
I saw it on their website,
On whose website?
on the All in Georgia.
Okay. Is that the same agenda, the agenda that you saw published?
Yes, yes,
Was the
sir.
same one you're holding in your hand, marked R2?
Yes, sir.
That's all that is.
Mr. O'Donnell, any questions?
Ma'am, are you certain? Have you done anything to verify your statement? The agenda was released to all in Georgia 1 week before the meeting.
It was, the reason I saw that published was because it was before I got a copy of the meeting. Before I got a copy of the agenda, and it was published on All in Georgia.
A week before January 17th.
I could not verify the exact date, but it was prior.
Where the All on Georgia website, and we'll get up here and verify it in just a minute, reports that it was published, released on January 16th, 2019.
It was published on their website before the day before.
The day before the meeting.
Before the day before.
Your testimony is it was published on their website and released to them a week before the meeting.
I don't know how many days before, but it was before the day before.
Nothing further.
Thank you.
Yes, I'm called. Young
Casey
lady from
Bryant.
All on Georgia. Casey Bryant. I need to rebut that statement. You solemnly swear from the testimony you shall hear and give should be the truthful truth, nothing but the truth, so help you God. Can you state your name, please?
Casey Bryant.
And Casey, how are you? Can you spell Casey? Because there's a lot of ways to do it.
It's C-A-S-I.
C-A-S-I-E, Bryant, B-R-Y-A-N-T. And how are you employed?
I'm the news director for All in Georgia.
How long have you been there?
4 years.
Are you assigned to this region? Okay. Have you been covering the school board? Do you receive releases from the school board?
I do.
Do you publish them on release?
I do.
When was the agenda released for the January 17th Board of Education meeting according to your file?
January the 16th, and it was right at 5 p.m.
And when was it published by you?
Probably 5:05, because everybody was waiting for it.
And have you done anything right now to verify that?
Yes, I've got the article that I actually published.
Did you write that article
Yes.
on that day?
Yes.
On one more time, what day?
January the 16th.
can go into the screen to see exactly what time that was posted. We posted at 5:07 p.m.
Do you believe you posted it somewhat contemporaneous with?
Yes, as soon as I have it.
Is that typical that the agenda comes to you, or comes to the public about a day before the meeting?
It is.
Thank you. Nothing further by way of rebuttal.
Any other witnesses?
No, sir.
Okay, so, you would have
I'll just kick
the
it.
only issue for me is whether this application for recall goes forward or not.
Right.
That's the only issue. To be clear, I cannot decide the other issue.
All right. The issue is multifaceted, you know. I'm somewhat applaud creativity. The policy, the board policy code of ethics of the school board is been admitted into evidence. And I want to refer to that policy, if I may, because I understand
Which one? The local
it's
school
the
board government?
local policy code of ethics of the
I got it, or the code of ethics.
Chattooga County.
Yeah, I got it.
Okay. And as I understand the position taken by the Petition, is that the public has the right to participate in every board discussion before policy can be passed. And they say that to do that, if they don't do that, it's a violation of the code of ethics. And the code of ethics is in various domains, as has been pointed out earlier. There is a strategic planning domain, which is number 2, in which the board, in paragraph 3, will work with the board and local superintendent to ensure prudent and accountable uses of resources in school systems. Then, in domain number 3, the Board of Community Relations, the Board and Community Relations. And it says the board shall seek regular and systematic communication with board and student, staff, and community, and it will communicate to the board and local superintendent expressions of public reaction to board policies. And they're saying, as I understand their position, is that because this board was newly elected, and hadn't had the chance to seek regular and systematic communication with the board and students, that they somehow could not act as a board without public participation in its meetings. As I understand, that's their position. And further than that, they're saying that if that happens under their provision, under their claim, that it is committed acts of malfeasance in office. That's the standard that we're talking about, Judge. The code says you shall, to recall an elected official, you've got to show malfeasance in office, or that he violated his oath of office, or has committed an act of misconduct, or is guilty of failure to perform duties prescribed. I mean, they're trying to recall an elected official because they didn't get to participate in a board meeting's discussion about policy. That's the essence of this whole thing. They don't want to go to a 5-day school system, and they want to recall anybody who does. And they're saying that Mr. Agnew, who cannot act by himself. Mr. Agnew is one vote on a board. And they're saying that Because, and obviously, a school board wants to seek, under paragraph domain number 3, a school board wants to seek and participate with, talk to the public. But to say that if you don't talk to the public or allow the public to talk, you have violated your oath of office and committed malfeasance to the point that you can be recalled from an elected office, to me is rather absurd, quite frankly. I mean, it's beyond my reason. Mr. Agnew, that's the issue before the court. Did Mr. Agnew prevent anybody from stating their position in that board meeting? And the answer is no. So to start with, let's look at the facts. Did the facts as alleged in this application occur? That's the start point. Did the acts occur? And it's clear from the testimony and the tape of the meeting that there was a full discussion. Quite frankly, I've been going to board meetings for 40-something years, and that's as much a discussion as I have ever heard on a policy issue with any board in a public meeting has. There was a full discussion. There was disagreement. There was a negative vote. Mr. Agnew wasn't even running the meeting.
The questions should have been.
Well, that's a good question.
There were places where you moved in, so that's a debate.
Yes, ma'am. My point is, even if you want to say he should have been or could have been running the meeting, did he on that tape prevent anybody from discussing the issues before the board? And I think the question is emphatically no. He did not. The question is, does the Board of Education, elected under our Constitution to have supervision and control of the school system, have to have public participation in discussions before they can vote on a policy vote? That's it. I'm kind of boiled it down as much as I can. They provide for public input through a process, constitutional process, of allowing people to sign up and come and vote and discuss to the board whatever they want to talk about. And the agenda on this meeting, there was no one who signed up. Nobody. But they wanted to participate in the board discussion. So does the board have to open up its meeting and discussions to the public who come and want to participate with the board in making its decision? I don't think so. And if they don't do it, should they be recalled from office? Have they committed malfeasance? Have they committed an alleged breach of the public trust, which I submit to you is not a standard in the statute? Breach of the public trust is not mentioned in the statute on recall. Is this particular recall application sufficient to give the public notice of what Mr. Agnew did? It doesn't say did not allow the public to participate. It simply says did not allow discussion. So is the people of this county going to vote because Mr. Agnew didn't allow the other board members to discuss it? It has to be an allegation with particularity. And this doesn't meet that test either. And to springboard an obligation of a board member to seek regular and systematic communication with among the board and students and staff, project that and propel that into an obligation of a board member to allow the staff, board, and students and the community to participate in a board meeting before he or she can vote on a policy change is a leap beyond anything I have ever heard discussed in my career. If boards can't vote, I guess they have to gather the public. We got a policy coming up, we may change it. Regardless of our rules, regardless of our policies on public participation, you all come and help us make this decision. That's not what the Constitution provides. That's not what the statutes provide. The school board controls and operates the school system. It establishes policy. That's what it does. Establishes policy. It's not based on mere conclusions of a recall application that lacks particularities, and it fails to allege conduct which would constitute one of the statutory grounds for recall. That language comes right out of the Supreme Court decision of Brooks versus Branch, cited in all of our briefs, I think. I really don't know how to conclude, Your Honor. I do know this. I know that members of the Board of Education, elected by the public of Chattooga County, voted to elect certain people to its board who campaigned on the proposition that they were going to return to the 5-day school system. And they took office, were duly sworn in, and considered, after a full discussion, whether or not to go from the 4-day system back to the 5. And they voted to go back to the 5. And how in the world that constitutes a violation of Georgia law, how that is malfeasance in office. The code section goes into definitions of malfeasance, willful misconduct, unlawful acts. And catapult a code of ethics provision to participate in public discussion with students and board members and members of the community. To catapult that into a proposition that they have the right to participate in board discussions, and if they don't have that right, the board can't act, and if they do act, they've committed malfeasance in office, is a leap beyond anything I have ever heard of. He's a duly elected person exercising his obligations as a member of the board, and that's not malfeasance. That's not illegal conduct. That's not a violation of his oath of office. And it's not, whatever this may mean, it's not a breach of the public trust. So the statute doesn't even provide for that term. So, I would ask the court to dismiss the
Judge, by way of conclusion, I'll address you back to where we started with the petition, which alleges that there was a failure to hold discussion prior to the action item. To determine then the reference point, I'm going to work back up the waterfall that I took you down in opening.
Well, would you, because I missed a step.
That's fine. The question is, what discussion? You watch the meeting. The discussion reference is with regard to this domain 4 of the Chattooga County Board of Education Model Code of Ethics. It's domain 3 and domain 4, but domain 4 is the most directly applicable. Domain 3 is the one that references seeking regular and systemic communications among the board and students, staff, and community. But domain 4 is the most direct. It says, make decisions on policy matters only after full discussion at publicly held board meetings. So the question becomes, again, as cited in the petition, full discussion. And that's where I'll direct you to the governance standards that I provided as secondary authority published by the State Board of Education that give more explanation on what each of these domains mean. What does it mean when we say domain 4? And what they said for domain 4 on page 10 of those materials is, the board provides opportunities for public review on proposed policies before final board action is taken. That's one of the elements of domain 4. It's actually element 4 of domain 4 on that page. So it's clear in my mind that domain 4 in particular requires some opportunity for public engagement to occur before a board action is taken on a policy matter. Now, counsel's absolutely right. I'm not quibbling with the authority of the duly elected board to make the policy decision in whatever way they so choose. That's their authority bestowed upon them by the public, the state, and the Constitution. Nobody's challenging their ability to do that. It's the process that they follow in this instance for doing it. And domain 4 clearly states that the public must have the opportunity for engagement, discussion in that. Discussion may or may not occur in the meeting, but in this case, that was the only forum allocated to the public, and we have to decide for ourselves, did the public have the opportunity at this meeting, because it was their only chance, on this policy matter. There's no evidence of any town halls or anything else. And I'm going to get into the campaign issue in just a minute. But the import of this domain 4 from the Code of Ethics is that we work our way back up. The Code of Ethics is mandated by Georgia law. Georgia law 20-2-72 is the code section that mandates that you follow and adopt the Code of Ethics. The breach of public trust is actually not irrelevant. It's in 4510-3, which is the general conduct of ethics for members of boards of the state of Georgia generally. And it says board members cannot engage in conduct constituting a breach of the public trust. We have our own code of ethics for Board of Education, so we really don't need to live over there. We got our own code here, which, as I just indicated, mandates public participation as a function of state law. And the reason that's important is the code section on recall petitions. He talks about malfeasance in office, but there are other sections. The fourth of which, in my mind, is the most clear. Guilty of a failure to perform duties prescribed by law. We just established, in my mind, my reading, that he has a duty as the chairperson. I'm going to talk about that a little more in a minute as well.
Let me say something. I have to ask questions.
Sorry.
The brain is working. I forget. And this is not an indication of what I might do, because I don't know what I'm going to look up some law. But could I strike some of the grounds of that?
Correct.
Do I have to take the application as a whole, or can I strike it? I know I cannot add to it. Can I strike it?
You could find, by way of my reading is, you could say, you do not find evidence sufficient to establish malfeasance in office.
Do you agree with that, Mr. Agnew?
I think they have the right to check one. That once they check all 4, they're going on all 4. That's my understanding of it. Pardon? So I would say you could not strike.
I'll look at it.
I'll be honest, in researching it, I don't know that.
I've got to research.
I don't know that I located that precise issue, but my reading of it is you can sustain it under any of the allegations.
I'll have to
And 4, I believe, in fairness, is the most direct. I believe the oath of office would apply, because your oath is generally to uphold the laws of this state, misconduct in office, but really, guilty of failure to perform duties prescribed by law. And I would suggest to you that based on what I just presented, the board, now this is what's important, you want to say there's no general requirement that you have public comment broadly. There's no, I can't say here's a constitutional provision or something that says you must have public comment in all meetings. In this instance, boards of education have imposed this upon themselves. When this state law was adopted and the model code was adopted, and adopted by each board of education, they restricted themselves in ways that they may not have otherwise been required. And in this instance, when they adopted this code of ethics and domain 4, and the documents and standards that come with it, they've imposed upon themselves this requirement that public review must be taken. So that leads us to the question of, do we have public participation discussion in this case? Did it occur? The board discussed it. At times, in the video you saw, the first, and you see it on the agenda, it says public discussion, none. And I think you heard that called out when they read through the agenda. There wants to be a reference to say, well, that's the opportunity for the public to come and address the board for 5 minutes about anything they want. And it is. And if you look at the form, you fill out the form for 5 days in advance and you turn it in, that's your opportunity to place something on the agenda. The agenda itself, in this case, is not published until the day before the meeting. So telling you that you have to turn in a form 5 days in advance to speak about something that's on an agenda that you haven't seen yet is not meaningful public participation. There was no way for anyone here, any of the public, to say, I would like to speak on this agenda item, because the agenda was released 24 hours before the meeting. And the form has to be turned in 5 days before the meeting. So to say, well, they could have filled out the form and turned it in and come and talked and no one did, is inaccurate. It was an actual practical impossibility before this was decision that was made for any member of the public, because they hadn't seen the agenda yet. And that's where it gets important about this board. Because what happened during the campaign and who they talked to prior to this meeting, they're not a board member. They're a candidate, they're a citizen, they're a lot of things. But this board, as constituted, did not exist until the start of that meeting when they were sworn in. So no matter who they talked to, they were not a board member. This was not the Board of Education doing anything, soliciting public review, public discussion as a board until the start of that meeting. Because they are not an elected officer and the board is not constituted until its members have been sworn in. So there was no way prior to this meeting for anyone as a, quote, board member or for this board to receive public input. Because they did not become a board member and this board did not exist until that meeting started. And when it did, that meeting fell under the control of its chairman. Now, the chairman can allow somebody else to sit there and move the organization through the meeting, there's no doubt about it. But he is the chairman of the board. And the authority over the board rests with him. At any point, as chairman of the board, he had the power to interrupt the meeting and say, this agenda item is out of order. It's a policy decision for which we have not had public comment. Interestingly, at 3 points in that meeting, you saw that issue come up. The first was when there was some murmuring in the back, and the one board member, who was the dissenting vote, said, kind of acknowledged the people, and then the board member next to him says, there's no opportunity for y'all to put your hands down, we can't get into that. There's a form you got to fill out a week ago, which of course is too late by that point. The second time public review came up is when the dissenting board member again raises the point where he says, perhaps we should stop this, do a survey, talk to the teachers, talk to the families, At that point, the chairman could have moved and raised this point to the remaining board members and said, we need to table this, I'm pulling this from the agenda, it's not properly before the board. That's within his control as chairman. He did not. And he's responsible for the actions and accountable for the actions of that board. And the last opportunity came right before the vote at the end when they said, we understand there's a lot of you who are here, but this is not the time for you to talk. You have to fill out the form, and no one did. And they cut off the discussion again. That again falls on the chairman as the elected chairman of the board and as the one responsible for running the operation of the meeting and the events that occur at the meeting. And so our position is that the public discussion, which is mandated moving up by the Code of Ethics, which is mandated by state law, constitutes a, quote, under the statute, guilty of failure to perform a duty prescribed by law. He did not, as the law mandates, adhere to his duty to provide an opportunity for public participation in this action item. And therefore, we would submit to you that the petition, as presented, should be sustained. Now again, as you have correctly noted, this does not mean somebody's out of office, in office. It sure doesn't change the school calendar vote. All this means is that the application for recall moves forward. What the electors of this county do with it from there is entirely up to them. It's not up to anybody in this room. And we would submit to you that's where this should fall, and that's where the decision properly should be made. Thank you for allowing us to make our presentation. And with that, I'll conclude.
I obviously got some things to read with the Brooks case. My concern is really fairly fundamental. And it's in the language that's in the application. That's what I'm bound by. I'm bound by the language that's in it. I can't recreate it. I can't. So I'm bound by it. And I've got issues with it. I've got issues of its sufficiency. I hate to throw something out on a technicality because I know that's not satisfactory to anybody. But I am concerned about some of the language in there. And I've got to look at what the burden is and what's the problem. And I know this judge didn't give any law in any of that. So, the one area I needed, I didn't get to look at. I mean, I have to take everything you said and do one thing, I have to take everything Mr. Agnew said and do one thing, but I'm bound by the language in that application, and I've got some problems. So I will try and get it done this week.
Thank you, Judge.
Thank you.